Recording in progress.
Are we ready, Carlin? Well, welcome everybody. Thank you for joining us at our last event for CTSC's last event for the academic year for 2021-2022. We are delighted to have had such a wonderful program this year, and I can't imagine a better note to end on. We are here for a wonderful program on Do Digital Markets Need a New Legal Regime? Views from Europe and the US. The great news is we have, through the miracles of hybrid participation, the opportunity for other people to be joining us. Even though the timing is a bit unfortunate purely from the student standpoint, the good news is they'll be able to share in the event. We saw a number of them virtually now and afterwards. But we couldn't pass up the opportunity to have this event because Professor Heike Schweitzer is visiting with us here at Penn for the week. And we are delighted to have this chance to welcome her into the community and to benefit from her insights. But before I proceed with the program, I do need to take care of two pieces of housekeeping. First, to let everyone know that this event is being recorded, and so we wanted to make sure everyone was on notice of that. And second, that for the benefit of people who are receiving continuing legal education credit, I will announce 3 words through the course of the event. The first one is sunshine, and please use that for your CLE forms to demonstrate your attendance today. All right, shall we? So it is my pleasure to introduce 2 outstanding speakers, without question 2 of the world's most eminent authorities on competition law and antitrust. On the far left is Professor Dr. Heike Schweitzer, who is Chair for Private Law, European Economic Law, Competition Law, and Law and Economics at Humboldt Universität zu Berlin. She's one of the leading professors on competition law and digital platforms. Since 2018, she has served as a special advisor to then European Commissioner for Competition, Margrethe Vestager, on future challenges in digitalization and competition policy. In 2019, she co-authored a report entitled Competition Policy in the Digital Era, along with a leading economist and computer scientist, which was the preeminent statement of policy in Europe at that time. Although 2019 seems like a long time ago. And since 2018, she's been co-chairing the German Governmental Commission Competition Law 4.0. So she's not merely a scholar isolated to the ivory tower, but one that engages in policy, and which is not to say that she's not a distinguished scholar in her own right, which is not to say that that isn't equally impressive. We also are joined by Herbert Hovenkamp, the James G. Dinan University professor, often called the Dean of American Antitrust Professors. He is the senior surviving author of the leading antitrust treatise and antitrust law, as well as numerous books and well over 200 articles. Is that right, Herb?
Never counted.
Well, I did. I stopped counting at 200, so the number's north of there, and so we'll leave it at that. As many honors would be too long to list, but just to name a few, has been named a Fellow of the American Academy of Arts and Sciences, was awarded the Justice Department's John Sherman Award for Lifetime Contributions, and recently received the Lifetime Achievement Award from the Global Competition Review. So we have 2 outstanding experts here, and with that, I will ask Professor Dr. Schweitzer to speak first. She will introduce us to leading developments in European law and German law. And then we will get commentary from Herb, and then it will be my pleasure to lead a discussion. Oh, and I can't help but to show this. In addition, Professor Dr. Schweitzer is the co-editor of a new book, Market Investigations, A New Competition Tool for Europe, which she was gracious enough to give me a copy of today. And so, with my thanks, I give you the podium. That will work.
Thanks a lot, Christopher. I'm very glad to be here today. I will not give an answer to the question, do digital markets need a new legal regime, in the 15 to 20 minutes to come, but only give you an overview of what the state of the law in Europe is, and then we will later have the chance to discuss. So, next one. So the European debate on platform regulation, and I think this is no difference from the US, really picked up speed in 2018, 2019. The background was a bit different from that in the US, in that we already had a lot of antitrust enforcement action in the EU since 2010. And we had, for example, we had 3 EU Commission cases against Google. This was Google Shopping, Google Android, Google AdSense. We had a large number of complaints against Amazon, which had been dealt with by national competition authorities. And we have a European Commission case against Amazon pending, still pending today. We also had a very controversial Bundeskartellamt, the German national authorities, case against Facebook, which was on a violation of the GDPR that supposedly translated into an exploitative abuse. So there had been a lot of antitrust enforcement action, but still there was a perception that this was not enough, in particular that this was not fast enough. Some of these cases, Google Shopping famously took 8 years from the start to the Commission decision, and now it's pending before the courts. Other cases were faster, but even the fastest cases took 3 years from the start until the decision by the competition authority was taken. So first of all, there was a concern about the speed, but then there was also a perception that there are specificities of the digital platform economy that lead to a special kind of power. Some call it gatekeeper power, others call it ecosystem power, which is particularly entrenched and durable, and that this type of power, the problems that go along, are difficult to tackle by way of traditional competition law enforcement because of the very systemic nature of the abuses that we see, and because our remedies regime is not very effective in addressing these systemic problems in time or in a timely manner. So what happened then? Germany pioneered with implementing a new provision, paragraph 19A, into our German competition law. The 19A regime was introduced in 2021. Since then, the Bundeskartellamt, the National Competition Authority in Germany, has opened proceedings against Google, Facebook, Apple, and Amazon. Google has already been found to fall under this provision. This was December last year. It has not challenged that finding, but there has no decision been taken until today on the obligations that apply to Google or to any of these other companies. In the EU, we do not yet have a law, but we are close. The Digital Markets Act is about to be passed this summer, sometime this summer. Again, the proceedings were really fast. The Commission proposed the Digital Markets Act in December 2020. We have seen the draft agreement by the Commission, the European Parliament, and the Council last month. And what we have also seen there is that what we would normally see in European legislation is the Commission makes an ambitious proposal, and then the proposal is diluted. But this has not happened this time. This time the Commission has made its proposal, and then the European Parliament proposed a tightening, the Council proposed a tightening. So we now see a much tighter draft agreement than the European Commission's proposal was. Again, this proceeding has been extremely fast, not even 1.5 years from the proposal to the draft agreement. And all this will enter into force in 2023. Now, these two provisions, 19A, or the two regimes, 19A and the Digital Markets Act, look quite similar because they address the same type of phenomenon, and many of the rules show similarities. Nonetheless, when you look look at these two regimes a bit more closely, there are many differences. And the differences start with the goals. The 19A regime is part of the German competition law, part of our abuse control. So the goal of 19A is protecting the competitive process against a new type of risk, a competitive risk, the risk posed by ecosystem power, but still it's the same type of goal, there's no difference. This thing looks different when you look at the Digital Markets Act here. The Digital Markets Act is not part of the normal competition law, which is in our fundamental treaty, Rather, it will be a new regulation. And Article 1, Paragraph 1 of this Digital Markets Act says that this new law shall contribute to the proper functioning of the internal market by ensuring contestable and fair markets for all business to the benefit of both business users and end users. This really sounds still like a competition law regime, but then you look at recital 10 of the DMA, which explains that this is an objective that is complementary but different from normal competition law, in particular because the rules shall apply independently from the actual likely or presumed effects of the conduct of a given gatekeeper. And then it's further explained what is meant by contestability. Contestability means the ability of an undertaking to overcome barriers of entry and expansion, and the DMA shall ban practices that are liable to increase such barriers to entry or expansion. This is normal competition law, I would say. But it shall also impose obligations that tend to lower these barriers. And here, I guess this is a step beyond the normal competition law regime. When it comes to unfairness or the fairness conception, then conduct of a gatekeeper is supposed to be unfair if, due to the gatekeeper's position and superior bargaining power, it can prevent market participants from fully capturing the benefits of their innovative and other efforts, or the benefits from their own contribution to the success of the network. And that also is something which goes beyond normal competition. Okay, then you look at the structure of the proceeding, and again there is an important difference between the German and the European regime. Both regimes come in 2 steps, but these steps are different. In the German regime, under step 1, the Bundeskartellamt will designate undertakings of paramount cross-market significance for competition. And then comes step 2, the Bundeskartellamt will then propose a tailored regime of obligations. It can choose from a conclusive list of 7 obligations, which are listed in 19A. It enjoys discretion on how to tailor the regime, but each obligation must plausibly address a risk for the competitive process, and the obligation then must be specified with regard to that risk. Also, the Normat Receipts will retain the possibility for objective justification. Under the DMA, you again have a first step. The EU Commission designates a gatekeeper, but in a second step then, a list of obligations, of 22 obligations in total, will apply to all gatekeepers alike, and will do so automatically. The Commission will not have to take any further decisions. So it's a one-size-fits-all regime. There is no ex-ante specification of how to implement any of these obligations case by case, and there's also no possibility for an objective justification. Looking at the Normat Receipts, again you see a difference. Of course, when both regimes are meant to address basically the same set of companies, Google, Facebook, Amazon, and Apple. Nonetheless, the Normat Receipts are described in different manners. Under 19A, the Normat Receipts are undertakings of paramount cross-market significance for competition, which are active on a multi-sided or network market. And everybody in Germany understands this to say that the Receipts shall be the providers of the largest digital ecosystems, with a particular importance for the economy. Now, the Bundeskartellamt, in order to designate one of these undertakings as a Normat Receipt, has to make an overall assessment of the following criteria at each case by case: dominance, financial strength, access to resources, including data, vertical or conglomerate integration, and relevance of the activity for access of third parties to markets. Looking at the DMA addresses gatekeepers. And gatekeepers are defined in Article 3 of the DMA as providers of a core platform service, and what that is then defined in Article 2, which is an important gateway for business users to reach end users. And in addition, this provider of a core platform service must have a significant impact on an internal market and an entrenched and durable position. But there's no thing that really links to ecosystems in that definition. So what is core platform service? Again, this is a conclusive list under Article 2, Paragraph 2. The list includes online intermediation services, search engines, social networking services, video sharing platforms, messenger services, operating systems, web browsers, newly introduced in the draft agreement, virtual assistants, also newly introduced, cloud computing services, online advertising services, and that's it. Then there is, different from the German regime, a quantitative presumption. So if you provide one of these services, which are defined as core platform services, and if you had an annual turnover in the EU of more than 7.5 billion for 3 years in a row, and you have at least 45 million monthly active end users or 10,000 active business users yearly, in that case you are a gatekeeper under the DMA. And this would apply to Alphabet, Google, Meta, Facebook, Apple, Amazon, but it will also apply to Booking, Alibaba, and TikTok. Not included are Spotify, Zalando, larger European platforms. There is a possibility for rebutting this quantitative presumption, but the hurdles are high. There's also a possibility for the EU Commission to designate additional gatekeepers, but again, the hurdles are high. So now we come to the rules of conduct that can be imposed, and we look first at the German rules. So what can the Bundeskartellamt do when they have designated one of these undertakings of paramount cross-market significance? If this undertaking is vertically integrated and is an intermediary, in that case an obligation can be imposed not to self-preference, with regard to ranking, with regard to pre-installation or integration of products or services. It can also impose a provision, an obligation on any type of Normat Receipts not to use their rule-setting power to hinder other firms in their commercial activity. And rule-setting now is to be defined broadly, including also technical designs that under the Lawrence-Lessig formula would be law in the form of code. So what would that mean? For example, a gatekeeper or an undertaking of paramount cross-market significance must not impede other business in reaching customers via other channels. In markets where platform envelopment strategies are likely, the Bundeskartellamt can provide that Normat Receipts must not hinder competitors, for example, by bundling, tying, or nudging strategies. The Bundeskartellamt can oblige undertakings not to create barriers to market access by way of data combination, this is the Facebook case, or by making use of other businesses' data for their own competitive purposes, this is the pending EU Amazon case. It can impose an obligation not to impede interoperability of products or services or data portability if this would likely result in an impediment to competition. They can oblige Normat Receipts to provide sufficient information about the scope, quality, success of services. This is in particular with a view to advertising services, which are very intransparent, and this information shall enable customers to compare quality and success and therefore make informed choices. And I leave out the last obligation because it's a specific one on ancillary copyrights. Now, what about the DMA? Here you, again, as I said before, these obligations will apply automatically, no further decision being taken by the Commission, and this list of obligations has really been expanded over the trilogue, over the legislative process. There are 3 forms of obligations now. First of all, Article 5, which includes those obligations which the Commission believes or the legislator believes are so clear that no further specification is needed. Article 6, those obligations where some specification may be needed, but where they will nonetheless apply automatically. And the new Article 6a, which provides for horizontal interoperability of messaging services. Now, what about Article 5? What are these clear obligations? First of all, data use restrictions. So, for example, this gatekeeper must not use third-party personal data for its own advertising services. It must not cross-use personal data between different core platform services, and it must not combine different data sets. All this unless the end user has given informed consent and a specific choice. And because we all know that we always consent, mostly, well, you have the specific choice requirement here, but still we don't know how effective this will really be. Then Article 5, litera B, the gatekeeper must not use exclusivity clauses or most favored nation clauses vis-à-vis business users. Business users must be free to offer their services through other intermediation services or direct distribution at other prices or other conditions. Article 5, litera C, even if the customers were acquired through a gatekeeper core platform service, business users must be able to promote their offers to these customers through other channels. So if you were acquired through booking, for example, the hotels must be able to transfer you to another distribution channel. Then Article 5, litera D, end users must be able to access content and items purchased from business users outside the gatekeeper core platform service through the core platform service. So the platform service really has some sort of common carriage obligation. I leave out Article 5, litera E, because it's not that important. Then Article 5, litera F, there must not be a bundling of core platform services with identification services or payment services. And there must not be a requirement for business users to offer or interoperate with such gatekeeper identification services. And then Article 5, litera G, the core platform services must not come as a bundle. So business users and end users must be able to take just one, pick just one, and not register for another one. And Article 5, litera H, there must be transparency in advertising services. This is the same rationale as in the German provision. Coming to Article 6, now these are the obligations where there remains room for specification, but they still apply directly. Article 6, litera A, the gatekeeper must not use data generated or provided by a business user of the platform for competing with a business user. This again is the Amazon case. Then there is a very broad, much broadened during the legislative process, Article 6, litera B, which prohibits the gatekeeper from steering consumer choice. So consumers must be allowed and technically enabled to easily uninstall any apps on the gatekeeper's operating system, to easily change default settings, and there must be a first screen for certain services where you can have a list of choices and then make your choice for the default setting. Article 6, litera C, gatekeepers must allow and technically enable the installation and effective use of third-party apps and app stores, and allow users to make these third-party apps and app stores their default. And they must be fully interoperable with gatekeeper operating systems, subject to a security justification. Article 6, litera D, no self-preferencing in ranking. This is the Google shopping case. Article 6, litera F, end users must not be restricted in their ability to switch. Then Article 6, litera G, a gatekeeper's operating system or virtual assistant must be fully interoperable with services and hardware from competing providers. Article 6, litera H, data access must be given to advertisers and publishers so that they can verify the performance. So again, on advertising services specifically. Article 6, litera I, effective data portability for end users must be ensured. And then there is a provision that business users must be enabled to access the aggregated and non-aggregated data that was generated by their own activity continuously and real time. Then there is a Google clause, so every online search engine provider must be given grant access, fair, reasonable, and non-discriminatory access to ranking query, click, and view data produced by a gatekeeper search engine, so this is really Google. There must also be friend access for business users to gatekeepers' app stores, search engines, and online networking services. And there must be proportionate conditions of termination for all core platform service. So you see it's a very long list. And there is now a new Article 6, litera A, obligation for gatekeepers to make basic functionalities of messaging services interoperable with other messaging services upon request. Now this is only for the basic functionalities, and then they try to define what basic functionalities are and have a complex regime on that. So according to Article 7, gatekeepers must comply with all these obligations directly and automatically when the DMA enters into force and when they are designated as gatekeepers. The Commission may open proceedings to specify some of the measures listed in Article 6 on their own initiative or upon request, and the gatekeepers may also request for the Commission to open a regulatory dialogue with them on the type of implementation, but the Commission is free whether to do it or not. There's also a very broad anti-circumvention provision. So Article 7a now makes clear that the gatekeepers really have to implement these obligations in good faith with a view to the goals pursued by the DMA. And if they try to kind of trick the Commission or be too ineffective in their implementation, they violate Article 7a. According to Article 12, there shall be a duty on the gatekeepers to inform the Commission about concentrations in the digital sector or where concentrations enable the collection of data. So it's really, in addition to European merger control, a different type of information duty. The Commission was asked to do more to really provide for a specific regime on mergers by gatekeepers. But this was not possible under the legal rule which was used to pass the DMA. You would need a different legal basis for changing the merger control regulation. What can happen now is that the Commission will then inform the member states, which may have authority to control these mergers, and the member states can then ask the Commission to do it for them under a specific regime in Article 22 of the European Merger Regulation. And also, if a gatekeeper systematically does not comply with the obligations under 5, 6, and 6a, then the Commission is authorized to prohibit a gatekeeper for a limited time from entering into any concentration. So now, and this is the end of this comparison. How do these rules compare by the rules of conduct in the DMA and under 19A? There is, as you have seen, a significant overlap, but there's a different structure. The DMA is much more specific and detailed and also absolute because you have no objective justification. Under 19A, these rules are broader, and then the Bundeskartellamt has to specify case by case, and they can only specify with a view to a specific risk or to competition. Both 19A and DMA follow a similar logic in principle. So both try to address risks of leveraging, and they follow a logic of ensuring vertical interoperability and anti-self-preferencing. There is generally no horizontal interoperability requirement apart from the messenger services, which came in, again, in the legislative process. And in the end, there is an attempt to regulate the strategy and the design of the platforms so as to make it difficult for them to hinder interoperability and a level playing field on the platform. Both 19A and the DMA emphasize the protection of undistorted consumer choice. Consumer choice is one of the words that appears most in both 19A and in the DMA. And both the 19A and DMA are very skeptical with regard to bundling, tying, self-preferencing, and any attempt of the gatekeeper or undertaking of paramount significance, cross-market significance, any form of steering consumer behavior, either by pre-installation or by default settings or by a manipulative design. Any type of competitive advantage that the gatekeeper retains for itself is viewed skeptically by both regimes, I would say. And also the logic extends to protecting the choice of business users regarding the degree of reliance on the services offered by the gatekeeper. So that even the business users shall have choice. But there is an important difference between the DMA and the 19A regime. To my understanding, the DMA really crosses the line towards a public utility regulation. Platforms are regarded as an infrastructure that must be available to all on fair, reasonable terms. So it has some sort of universal service or common carriage logic. There is an obligation under the DMA, but not under 19A, to proactively lower barriers to entry and to proactively enable innovation. And then there's a fair sharing obligation in what is perceived as a collaborative value creation. So the logic of the DMA seems to be everybody participates in creating the value of the platform, so everybody has to have a fair share. And this is again different from 19A. 19A really remains committed to competition law goals. It's quite proactive in some respects too, but still you always need a kind of, not a theory of harm, but rather a theory of risk. There is, under 19A, no further reaching logic of universal service or common carriage. This is not present in 19A. So this is it as an introduction comparison, and I leave it at that.
Thank you very much, Professor Schweitzer. You going to speak from here, or?
No, I'll speak from
All right. In that case,
Thank you.
we'll make it so you are no longer Heike Schweitzer. And make sure you are Herbert Honkamp.
Thank you.
I don't drop you. There we go.
Well, thank you for inviting me here. So I'm going to look at the same set of problems, but from a U.S. perspective, and I will venture an answer to the opening question whether we need a new regime for large digital platforms. And I think the answer for me is no, we don't. We need some new fact-finding, and we may need a little bit new economic theory, but it's not qualitatively different from what antitrust policy has done over the decades. We had to learn a lot about telecommunications back in the 80s when we were going through the US versus AT&T restructuring. We learned a lot about pharmaceuticals when we went through the antitrust issues involving the Hatch-Waxman Act and abuses of the patent system. And now for the last several years, we've been going through digital platforms and markets. I think the theory can be made to fit, although we do need a certain amount of new theory. One thing we've confronted with respect to digital platforms is market two-sidedness. The idea that the operator of the platform is not so much a market participant as an intermediary between other participants, like Uber, for example, Amazon in many cases, Google. And two-sided markets are complex. They are frankly complex, and they have needed a lot of theory, and there's an entire cottage industry out there of microeconomists devoted to studying two-sided markets. Year before last, in the Amex case, the Supreme Court first explicitly confronted two-sided markets and frankly didn't do all that well. The fact is, two-sided markets have been in front of the US Supreme Court many times. It just didn't have the lingo or the tools for evaluating them. So for example, the Chicago Board of Trade case from 1918, which involved a market, a pre-digital market that regulated relationships between sellers and buyers of grain and livestock, was a two-sided market. The broadcast music market of the late 70s and early 80s, which involved digital music rights for the most part, continues to be a two-sided market. And the Supreme Court decided cases involving those markets without ever employing the rhetoric of market two-sidedness. fact, I think did better in the broadcast music and Chicago Board of Trade cases than it did in the Amex case. So we've got some learning to do, but I think the fundamental questions are pretty much the same. Now today we're talking almost exclusively about remedies. And here, just let me say a couple of things. Number one is most big digital platforms are not winner-take-all markets. Well, that's a controversial statement. There's a lot of people who disagree with it, but I think in fact, there are some big platforms and there are a few winner-take-all markets. A winner-take-all market is a market which has an equilibrium number of players of one, as it naturally gravitates toward a single supplier. The neoclassical term has always been natural monopoly. But there's one very important difference between digital platforms, even the big ones, and the theory of natural monopoly, and that is people who wrote about natural monopoly generally supposed that the various market sellers all faced exactly the same demand. That is, they were undifferentiated. Electricity, telecommunications, the only bridge through over a river or a railroad through a mountain pass. In all those cases, there might be, quote unquote, room for only one firm in the market. But most digital markets are not that way. Most of them are subject to large amounts of product differentiation. And as a result, new entry is common and possible and common. So for example, if the question were, to what extent could a Facebook clone, as somebody who offered exactly the same set of services as Facebook, maybe change some names to avoid trademark problems, but to what extent, what would be the prospects for a Facebook clone to come into that market and succeed? And I think we'd probably concede that the answer is not very high. Facebook's installed base of users, advertisers, and everything else is just overwhelming. And so an identical firm, a firm that faced the same demand, would not succeed very well in Facebook's market. But that's not where the entry into the Facebook market has occurred. It's occurred from firms like Twitter and TikTok and LinkedIn, all of which survive and even do pretty well. In fact, Twitter was just sold today for a little shy of $50 billion to Elon Musk. It hasn't been sold, but there's a deal in the works. Twitter does quite well. And the reason these firms do quite well is because they all offer differing packages of goods and services and appeal to overlapping but distinct groups. And so what do you get? You get a rolling set of dominant firms, new entrants, some of which will eventually become dominant. And that landscape is not all that different from the industrial landscape that we've had for generations. We've always had periods of dominance and other firms coming in and taking over and so on. And the digital market doesn't look all that different. Now, there could be a few digital markets that are winner take all. And that's because there are some markets in which effective product differentiation is not very possible. Search engines is a good example. And there, of course, we've got Google, which maintains a fairly stable 90+% market share of general consumer search because it turns out companies have tried different things. They've tried security mechanisms, different search algorithms, and so on. Turns out there aren't all that many effective ways to differentiate one search engine offerings the way there is, for example, with Facebook. And so Google search might in fact be a winner-take-all market, but I think it's in a minority of such markets. Okay, now what's the importance of saying that something is not a winner-take-all market? And that is that a winner-take-all market wins by simply being there and offering competitive or slightly super competitive terms. That is, say, if the equilibrium number of firms in a market is 1, the only thing you need, once you reach that status, all you need to do is continue in business, and others are not going to be able to succeed against you. If you're not a winner-take-all market, however, you're probably going to need exclusionary practices in order to maintain your dominant position. And I think that's a much better descriptor of the story. It is certainly the premise in the US Facebook and Google cases. That is to say, the premise in Facebook is that competitors could emerge into the chunk of social network services that Facebook provides, but that Facebook's activities, principally exclusionary contracts and mergers, have prevented them from doing so. But the basic problem, I think, is exclusionary practices and not simple winner-take-all status. Okay, so then that gets me to the question of skipping over this really important question in the middle is, when do big digital platforms do things that are wrong? That's not what we're talking about here. That's a very long discussion, but what should the remedies be once we have found that digital platforms have done something wrong? We do not have any rule of no-fault monopoly in the United States. I don't think we're likely to get one. We don't have rules yet, like Professor Schweiker was just talking about, that may impose additional obligations on firms simply because of their large size. We may get some of those as well, but we don't have them right now. But assuming a firm has committed an exclusionary practice, what should the appropriate remedy be? And that's something that's addressed comprehensively in the Digital Markets Act, in which I am not an expert, and it's been addressed for decades with respect to US firms under US antitrust law. Here, you've got a wide variety of alternatives. You've got simple prohibitory injunctions. They're the cleanest and simplest. At the other extreme, you have breakups, which is to say you force firms to divest certain assets. And then in between, there are a range of equitable remedies, that is, things a court can do, and the federal courts have a lot of power here. In fact, the Clayton Act gives the federal courts virtually unlimited power to design decrees that will restructure either the firms or the practices in an industry in order to produce more competitive conditions. That doesn't mean it's a good idea to do a particular thing, but only that the authority is there to do them. So there's a wide range of remedies that are less draconian than a breakup, but yet more aggressive than a simple prohibitory injunction, okay? So I'm going to go through some of these. We can talk about them later on if you want, but I think the one that's most easily justified most of the time is a prohibitory injunction. If the defendant is doing something wrong, get an injunction to stop it. That covers a lot of territory. It can cover things like most favored nation clauses when we're dealing with Amazon and its merchants, or with advertising contracts respecting Facebook or Google. But frequently the best solution is also the simplest, most obvious, and oldest one, which is get an injunction and order the firm to cease and desist from whatever it has been doing. Okay, then going way to the other extreme, when are breakups, that is actual divestiture of assets, called for? Well, I'll say it this way. First of all, rarely to never, if we're talking about firms that have developed entirely through internal growth. That is to say, if a firm has just come up, developed its own processes and business relationships and activities internally, breaking up a firm of that nature is foolish. To say that judges are bad at determining how markets or how firms should be broken up is a severe understatement. We should try to avoid having to break up industries that have, or firms that have developed by eternal growth. Now, don't confuse that with divestiture of acquired assets. That's a totally different problem. Divestiture of acquired assets is a very old remedy in antitrust. It goes all the way back to 1904, the first Supreme Court case that ordered divestiture was the Northern Securities case. Before the Clayton Act anti-merger provision was even passed, it was a challenge to a holding company, New Jersey holding company that acquired 3 east-west intercontinental railroads. The Supreme Court did order a spinoff of those acquired firms. And today, to this day, breakups of recent mergers are not at all uncommon. Now, we do a lot less of it since 1976, when the Hart-Scott-Rodino Act was passed, because what that act facilitated was pre-merger notification and then coming along with that pre-merger challenges. So today, most of the mergers that the government challenges are challenged prior to their occurrence. And as a result, a breakup isn't necessary because the firms never merge to begin with. So we really need a breakup only for post-acquisition challenges, and we still have some of those, several of them, as a matter of fact. In fact, the Facebook case, the one that the Federal Trade Commission brought against Facebook and that is now, has now gone into discovery, involves a challenge to 2 acquisitions, WhatsApp and Instagram, and the FTC's request that they be broken up. That is a pretty orthodox remedy within the antitrust laws, breaking them up. Now, there's a couple of peculiarities about this one. Number one is the acquisitions were fairly old. They occurred 8 or 9 years ago, and they were actually approved by the government agencies at the time they occurred. There's no res judicata on approval of acquisition, unlitigated approval of acquisitions in the agencies, but there's no formidable technical or principled reason to say that acquired assets cannot be forced to be spun off. Now, it does raise a few other issues. The principal one being, how well have the integrated assets, have the acquired assets been integrated into the parent company? In the extreme case where the acquired firm has been completely sucked in, for example, if a predominant portion of the acquired firm's assets are intellectual property rights and the acquiring firm has just assumed them and put them into its structure, well, in those cases of complete integration, the breakup problem is not all that different from the one of assets that developed by internal growth. Most acquired assets are not in that category, and interestingly, the 2 Facebook acquired assets are not in that category. Neither Instagram nor WhatsApp have ever been fully integrated into Facebook. Instagram still maintains a separate website, a separate consumer platform and customer base, and not very much interoperability, although there is some. And pretty much the same thing with WhatsApp. So I don't regard those as abusive. Now, they may lose on those issues because of the fact that those mergers are pretty old. The states lost under this equitable doctrine called latches, which prohibits private plaintiffs from bringing stale equity cases. But latches doesn't run against the federal government. So there's some technical issues that need to be worked out, but I think the spinoff of Instagram And WhatsApp is a fairly normal, historically justified application of antitrust law. Going after other firms by simply, taking a buzzsaw and breaking them into pieces, it will do much more harm than good. First of all of the large digital platforms are subject to significant network effects. We've got the power to break them up, but if you break them up, well, how would you break up Facebook? How would you do it? Put all the boys in one and all the girls in another one? Well, that's not going to work. Put everybody east of the Mississippi River in one and everybody west, or tell Facebook they can no longer post videos. We're going to divest your video business. That is to say, the courts have the power to make Facebook a less attractive program through a breakup. They've got the power to do that. They could ruin Facebook if they did it and equivalent remedies were not imposed on other people. But none of those is a good way of restoring competition. Okay, then that finally leaves a couple of intermediate remedies, and I'll shut up. One is shared governance, a largely ignored remedy that I think needs to be reconsidered. In the history of antitrust, there are many, many cases that involve incorporated entities whose managers were competing firms with separate interests. Chicago Board of Trade was one. Justice Brandeis never discussed the issue. Chicago Board of Trade was an Illinois corporation. Its shareholders were individual traders. Now, if a corporation establishes a pricing rule, which was what the rule that was challenged in the Chicago Board of Trade was, it'd be a purely unilateral act and nobody would ever challenge it under the antitrust laws. The fact is there was an agreement among the shareholders of that corporation to fix a price in a certain way, with the all-important distinction that the shareholders were themselves business entities that had separate businesses of their own. Associated Press. Associated Press was the second, actually, very large wire service for sharing news content. Associated Press was an incorporated association, and its members, however, were newspapers, each of which had its own business, and the Associated Press rule had to do with who could be a member of Associated Press and share news stories. And once again, it's the 1940s. Without even discussing the issue, the Supreme Court had no problem holding that Section 1 of the Sherman Act applied, and that collective rule excluding certain members ought to be condemned under the Sherman Act. Most recently, in a case called American Needle versus NFL, that was a case that involved NFL Properties, which is the intellectual property licensing organization of the NFL, owned by the separate individual NFL teams. And NFL Properties basically licenses out all of the various trademarks and so on of the NFL teams, and the Supreme Court had no difficulty deciding that agreement should be treated as a cartel of its members rather than a unilateral action. And you could do very much the same thing by decree with, for example, a company like Amazon, which is to say, create a board that has the power to engage in product selection, distribution, placement, and so on. Probably not pricing. Currently, Amazon's stated policy is that merchants set their own prices, but this board would be constituted, would be made up of individual firms with separate businesses who then make all of the relevant decisions about contracting out with respect to Amazon. And the all-important difference in these cases is that collaborative activity is governed by the agreement standard, the agreement and restraint of trade standard of Section 1 of the Sherman Act, which is significantly more aggressive than the monopolization standard of Section 2 of the Sherman Act. And incidentally, it also lowers the market power requirement, and there are serious problems establishing market power with respect to the large digital platforms who have, they're very big firms, but for example, Amazon does not have a dominant market share in very many products, setting aside ebooks. So shared management is a prospective remedy, I think, that needs a little further thought. And then finally, interoperability is something that Professor Schweiker talked about briefly. It actually has a longer history in US law than most people know. US versus Terminal Railroad was a case decided in 1912 in which in this case, a Missouri corporation owned by several railroads, loading facilities, warehouses, 2 bridges, got together and entered into restrictive agreements about who could use those facilities to transport across the Mississippi River at a very critical juncture. At the time, there were basically three places you could get across the Mississippi: Chicago, St. Louis, and New Orleans. And the Supreme Court issued what was basically an interoperability decree. It said, you guys can establish whatever rules you want to interact with one another, to hand off packages, schedule trains, take care of storage of warehousing of goods that are being transported across the river, and so on. But any rule you make must be applied without discrimination in favor of third parties. The AT&T consent decree, which has gotten a lot of attention in the last 4 or 5 years, also mandated, first of all, the first thing the AT&T consent decree did, this was in the early 80s, was break up the phone company, AT&T, into 7 regional operating companies, a long lines division, spun off an instruments division. But one of the things it had to do was make sure that those various pieces could still talk to each other. And so there were interconnection agreements. New companies that wanted to come in under the consent decree were entitled to come in and interconnect. And of course, the regional companies had to be able to interconnect with each other. For roughly 12 years, that decree was managed by one, bless his heart, I hope he's in heaven in a really good place, Judge Harold Green. I can't think of a worse job than that, managing interconnection disputes for the phone system. You can probably think of worse ones. And then finally, that obligation was taken over in 1996 through legislation. So we've got a good, solid history of interconnection. Where will it work? Well, it won't work everywhere. I think, and there's 2 issues that Professor Schweiker kind of hinted at. One is data portability, and the other one is real-time interconnection. Data portability is frequently the easier one to achieve. So for example, one of the things in the Facebook decree that the judge cites in his decision sustaining the complaint was that one of the barriers to entry, as he called it, was that the aggregated information that each individual Facebook customer has built up, and depending how active you are and how long you've been a member, that could be a pretty good amount of stuff. It's not available in any compact, digitized form that could readily be transferred to a different social networking site. And I expect that, or something like it, to be litigated. I don't know if it'll be successful. I don't know if it'll be the result of a consent decree, but one of the issues in the Facebook case right now is whether a common saving data into a common transferable form is part. And I think here is one place where US courts are, or at least should be, looking to the EU, the Digital Market Act in particular, which is much stronger on data portability than US law is. The one experience we've got is administrative, and that's phone number portability, which did not come along with the original AT&T breakup, but came along later. And it was fairly controversial when it was developed. But basically, you know, one of the barriers to people switching carriers was you'd lose your phone number. Well, the Facebook barrier sounds a lot bigger. You're losing much more than your phone number. You're losing your entire built-up history. But we did achieve number portability, not through the antitrust laws, but legislatively. And of course, today you can carry your phone number with you as you migrate from one carrier or one device to another one. So, you know, there's a lot of discussion about both interoperability and portability in antitrust today. I would say about 95% in the secondary literature and a tiny, tiny amount in the case law. People are still working on these, but under a constraint in the Clayton Act, the equity constraint in the Clayton Act, that the goal of a remedy should be to restore competitive conditions. I think they are well within the reach of existing U.S. power under the antitrust laws. I think I've talked long enough, so thank you.
So Heike, unless I missed my ideas, you look like you're itching to say something. Am I correct?
Well, actually, I have some questions. Because you now answered the question from your perspective, do we need special digital rules? I would say, if I now try to answer that question from my perspective, I would say when we issued this report for Commissioner Vestager, this was still based on the premise that we do not need a regulatory regime, but that Article 102 could do the job. When I kind of started to rethink that position was when I did a survey of all of the litigation on the digital platforms, on the large ones, that has taken place over the last 15 years or so in so many jurisdictions. And what you see is a very systemic practice of abuses. And enforcing the prohibition of abuses is hard, even if you make it a bit easier by changing the methodology at this point or another. It remains a lengthy process. And if you see that you kind of impede one of the abuses and the next 7 have already lined up, and this is about to do significant harm to competition, at that point I would want to think again about the need to do something else. Now, I think part of the problem in the EU, and this is in a way my first question to you, the part of the problem is that in the EU you have broad remedial powers like in the US, but what we can do only is to prohibit the specific type of abuse that has occurred. And you cannot say, well, this same type of abuse can happen in so many other markets because we have an ecosystem provider now that is able to control a variety of markets. So we don't want to wait until the next abuse occurs in a different market, but we want to change the market now. So this is something we cannot do under our remedial regime. Can you do that?
We can, subject to one very important limitation, and that is you have to have jurisdiction over the parties who are going to be the subject of this decree. But you can reach conduct, and consent decrees clearly do it all the time. They reach conduct beyond that which was actually challenged. On your first point, though, I agree with you that it's hard to do this through the judicial process. The thing is, I have very little confidence that our Congress is going to be able to do it any better. Mm-hmm. In fact, my money would be on the judiciary. The legislative proposals range from the few of them I would regard as sensible, but many of them are really quite fantastic. And so if our goal is to make these markets more competitive without undermining the incentives to invest and innovate, my money is still pretty much on the courts. But you know, that's a debatable question.
Okay, but then just to ask again, let's say we have seen the Google Shopping case, whether you like it or not, I don't know, but you say here we have self-preferencing which can harm competition. Now we have a different type of self-preferencing, let's say in whatever hotel booking markets or whatever it might be. And can we now, because we have seen self-preferencing to harm competition in one market, say we prohibit you self-preferencing practices more generally?
Well, first of all, I would not assume that self-preferencing is always a bad thing.
I agree, but in Google's case,
well,
maybe...
okay, if you've got a dominant firm with a clearly dominant position in the market that is subject to self-preferencing. I mean, I'll just give you an example, one that I happen to know because I've encountered it recently. Amazon is a very, very big firm. It has a 22% market share of small kitchen appliances. So this is toasters, blenders, toaster ovens, mixers, you know, the collection of electric devices we have in our kitchen counters. It's the same size as Walmart, within 1 point of Walmart. And then there's several other firms that trail off behind that with market shares in the 10 to 15% range. Costco is one of the bigger ones. Target is another one. Do we need self-preferencing rules in a market like that? Well, a couple of things. First of all, and remember, we're not pointing our guns at Walmart, we're pointing our guns at Amazon. Okay, if you're in Walmart and you get stuck in a situation where Walmart is preferring its own version over a version you would prefer, you can switch, but you got to go out in the parking lot, get in your car, and drive to a different store. If you're on Amazon and you don't like their self-preferencing, you just click your mouse and you're over at the Costco or Target or Walmart websites, and you can buy from them. So, you know, self-preferencing rises to a level of competitive significance when it is effective at denying people competitive alternatives. And in order to do that, you've got to have a fair amount of market dominance. And then secondly, you've got to have some kind of limitation on consumers' ability to switch. And if you don't meet those conditions, if people can just go willy-nilly to whichever source they want, then I don't think we want to intervene in that.
Well,
I am remiss in one of my few responsibilities, which is to give the second CLE word.
Oh, you're remiss in
It is window. Without, and I'll leave it at that. Now, if you would.
Yeah.
Window.
Second CLE.
Second CLE word is window. Please.
on self-preferencing, well, I wouldn't say I wouldn't argue in favor of a broad general self-preferencing prohibition. I think we have the problem in case of very significant kind of power, and I even would limit it to ecosystem power. And secondly, what you need but what you have, and this is the difference between Walmart and Amazon maybe, although I'm not sure whether I would argue in favor of self-preferencing prohibitions in the Amazon case, but the difference is that Amazon, the self-preferencing will frequently not be visible to consumers, and Amazon has a lot of possibility to steer. Okay, I see Walmart can do it too because they can place it on the shelves here and there, and they can, or you don't see what type of alternatives they have not incorporated in their offers. But still, I would say the amount of steering, conduct steering that happens in the digital world in a targeted manner based on a lot of knowledge about consumer behavior is broader than in the brick and mortar world.
Well, maybe. Switching costs are pretty low on digital markets. And Amazon, you know, has alternatives. But yeah, we can leave it there. The Amazon buy box has been a big source of contention with respect to self-preferencing. If you look up a product, you'll see featured one version by one seller at one price, and then you go down the page a little bit and you see something like other ways to buy, and you click on that and there'll be a whole list of other people. And, you know, as I'm sure you know, behaviorally, something like 95% of the customers call that up and they buy the thing that Amazon has pre-selected. And then the question becomes, is Amazon behaving fairly among those various sellers when it prefers one, and particularly when it prefers one that it's distributing itself rather than through a third-party merchant? Well, you know, I think it depends a lot on how irrational we think consumers are, how abusive Amazon is. I think if Amazon were consistently abusive, that is, you know, if consistently Amazon was not putting the lowest priced product in the buy box, but if you click down below, you'd find the same product cheaper, I don't think it would take too long for that word to get out.
So to channel my inner Herb Hubbenkamp, you have a lovely article on the regulatory review looking at one particular market, which is batteries, where the private label for Amazon is much cheaper priced and is yielding consumer welfare. So I think, you know, my take on what you're saying is the definition in the DMA applies to all of Amazon in all of its markets simply by virtue of size. And that it's a bit of a blunt instrument, which makes, I really want to draw you out a little bit, because you've been quite agnostic about your comparison between the DMA and the German code, and the Section 19A. One is a more regulatory focus, and then the German Section 19A more traditional towards competition law. Do you have an opinion on which one's better?
Well, I have a clear preference. I prefer the German version, and not because of my nationality, but because I think it's, I'm still in favor of a regime that's much closer to competition law. I would even have a different favorite, which would be, and this links to the book, Market Investigations. I would have preferred the new competition tool. I would prefer to have a regime where we would have enabled the Commission to react to a systemic problem in a systemic way. So if you have, let's say, 3 normal abuse proceedings where you see Google is self-preferencing in different markets, and it's doing so systematically and is hurting competition by doing so, then they should have the ability to issue a remedy which is broader than the markets which have been affected. And if the Commission would have had that power, I think we would have been rid of many of the problems that we now have with the DMA, and that we have with the ecosystem power, and we would not have switched into this heavily regulatory regime which we see now in the DMA. So I don't think and the problems will come obviously with the DMA. So all the Article 6 obligations, let's even accept that Article 5 is so clear that nothing needs to be specified, which I'm not sure about. But even let's accept that, but then there are all the Article 6 obligations, and the amount of regulation that you have to do to implement those, this is worse than what was it, Justice Green did in, in the telecommunications sector. This type of regulation is even more intrusive because you have to decide on design choices and how at each moment, and not one, but a whole amount of them. So I don't see how this challenge will be met by the Commission with the manpower they have.
So I can't help but tease you out now, Herb. So we have in the DMA a much more regulatory turn away from traditional competition law principles. We have a lot of US legislative proposals that to my eye would do something similar, which is, again, size thresholds instead of our normal effects analysis. Would you agree with that characterization, and how would you feel about the same question being posed in the US?
Descriptively, I agree with it. There are several of the bills, including the leading self-preferencing bill that identifies its participants by size, caused a little bit of a kerfluffle in Congress about a month ago because Facebook took a major hit in the stock market and fell below the statutory threshold. But I think it's a bad idea to identify covered firms without regard to market share. I mean, the reason these firms are very big is because they operate in very big markets, you know. How many people do you know who are not on Facebook? They're huge markets, and as a result, the gross size of these firms is enormous. But when you start looking at market share, you know, you get a whole different story. That's the easiest to see in the case of Amazon, because Amazon sells tactile products, and we've always been able to measure market share there. But no, I don't like the idea of identifying targets for special treatment on the basis of raw size rather than market share.
Mayor?
Please.
Which market share would you choose, though? Would you say it must be clear dominance beyond 50%?
No.
So I ask you because I think this concept of ecosystem is important. And an ecosystem can be powerful even if you have an oligopoly.
I think network markets need to have trigger points at lower market shares than standalone markets because they depend on cooperation for their success. Under current law in the U.S., monopolization requires something around 60% as a minimum. Section 1 for agreements, that's why when I talked earlier about collaborative activity, hovers closer to around 35%, which is probably a place where I'd want to give it close scrutiny. But you know, what you really want to know is to what extent can consumers realistically find alternatives? And you know, if that market share is 5%, then that creates a pretty strong presumption that they can. If it's 60%, boy, that involves a much harder look. But yeah, it's still ultimately a question about market share rather than simple size, in my view.
So before, just to tell the audience to get ready, we'll carry on this a little bit longer, but we will have some time at the end to entertain questions. So if you start thinking about them and preparing for them, I'd invite you to do that.
Just to question you on that again, would you, when you say, when can consumers realistically find alternatives? Would you look at consumers as they are, with all the biases that they have, or would you have an ideal concept of an informed, clever, smart consumer who makes good choices?
I would start out by running a few intuitive searches. Search for electric toasters, not on Amazon, but search for it on Google search or some alternative search engine and see how many sellers there are. Because the first thing you find out is that you will get a listing. Amazon may or may not be at the top. Frequently it's not, but it turns out that, you know, Walmart and Costco, Target, lots of other firms are listed in that search. So the idea that consumers do not have those alternatives, at least in that example, seems a little far-fetched to me. Now, if you're talking about advertising on the internet, which is heavily dominated by Google, then you've got a little different scenario. But there are many markets on the internet that don't have alternatives, including, you know, classic two-sided markets. But, you know, that's a fact question ultimately, and the one thing I don't like about these size categorizations is that they decide it legislatively and preemptively without ever asking whether it was necessary. Before we open up, I just want to point out one fact that always kind of makes me more humble when I'm in this area, and that is, you know, economic growth in the U.S. and in the world has been running over the last 10 years, you know, mainly in the 1% to 3% range. The digital economy, of which where all of these firms participate, has experienced economic growth roughly 4 times that size. That is to say, a very significant part of economic growth comes from digital markets. And I think we need to be a little cautious about, diving into those markets with a chainsaw and tearing them up, because we have the capacity to ruin them if we want. But I don't think that should be our goal.
So I'm going to resist the temptation to ask you about your 35% threshold, because I find that fascinating, because that would be a 3-firm market. But I'm going to actually take a couple questions from the audience. The first one, we have one that's coming online, asking about Apple's recent restrictions on advertising companies, as you know, that on their iPhones. It prevents gathering of user information by other platforms, which means that Apple gets preferred advertising data. The question is, would that be subject to reversal under the DMA?
I think the DMA, let me think about, there is an Article 102 proceeding. There's also a proceeding under German law, which was under the normal abuse prohibition. And the Bundeskartellamt shifted that proceeding to a 19A proceeding. So 19A would be able to catch that. Would the DMA catch it? Restricting access, there is this one provision about, I really would need, I'm not yet very familiar with all the prolonged list of Article 6 provisions, but I think maybe it could be a restriction of companies accessing other parties, but it's not, what was clear was in the old version of the first proposed version of the DMA, this was not caught by any of the prohibitions. And this was a concern in the legislative process, so they tried to add and add more and more provisions, and I would need to have a look at the new ones. What I'm sure about is that even if this can now caught by the DMA, the next practice, which cannot be caught, will surely come. So and then you will have to add and add and add more prohibitions to the list, so it's a very inflexible regime that is created over there.
But it would be caught by Section 19A under the German law.
Well, this is something that the Bundeskartellamt is exploring, so they consider it likely, I think. And the problem, and the Bundeskartellamt already considered it likely to be prohibited under Article 102, essentially because they try to regulate the market to their advantage. So others don't get the data they need to enter the advertising markets, which Google and Apple, Apple doesn't dominate the advertising market.
This is where I like this is my concern about leaving effects in traditional competition law. The primary person being hurt by this is Facebook. And we've been complaining about a market dominated by Google and Facebook in advertising. And what the basic move, even accepting the assumptions of this question, is this is making Apple a more effective competitor in the advertising market. And there's an argument from an effect standpoint, this would be beneficial to consumers. And perhaps they say Amazon is now emerged as the #3 advertiser, and Apple is a potential #4. This could be a good outcome. Now maybe we'd prefer it to be in another non-platform actor, but it could be that this is the best form of venture we're going to find in the advertising market. So I'm fascinated by whether does this confirm that the competition law is the right approach, the regulatory approach is the right approach? What insight does it give us?
Well, I don't know. I haven't seen any proposal by the Bundeskartellamt or anybody else on how to deal with it and what the theory of harm is behind this. But I probably would suspect that it's not about advertising. I don't think that Apple is going to enter into the advertising market and challenge Google and Facebook, because this is obviously not the business model of Apple. Rather, they are trying to convince the consumers that they are very cautious with consumer data. What they do, though, is use consumer data in their ecosystem. And so I would rather suspect that if I were in the Bundeskartellamt and were to write this complaint, I would rather focus on what can they do with these combined data sets to leverage or reinforce their power within the ecosystem and foreclose others who may need that data in order to enter into those markets. So probably I would focus on that and not on the advertising market.
And so you'd look at their approach of looking at a theory of risk, customized remedies, instead of the automatic approach of the DMA.
This is a crazy approach. To my understanding, it's a crazy approach because as you see when you go through the list, with each provision, each prohibition, the Commission or the European legislator targets a specific undertaking, and they have in mind a specific case where this made sense to them. But obviously, this doesn't. If you have a completely different business model, it may not make any sense. And therefore, to just expand these provisions and impose them on everyone, I'm not convinced of that.
It's a very interesting lens on the questions, the dichotomy you're putting out forward. So Herb, we have a question I think is best asked to you. Could you discuss whether the FTC rulemaking has any role?
Yeah, I think it does. I mean, most of its potential lies in the future, but the FTC is in a unique place to anticipate anti-competitive practices and make administrative rules that are presumptively valid until a court strikes them down. This is as opposed to guidelines, which the FTC can also issue, which are not enforceable, but they're simply, like the merger guidelines, for example, are not presumptively enforceable, but the courts, in fact, do follow them. And the one thing we know from years of litigation with respect to both agencies in the U.S. is that the courts like rules and guidelines that are made outside of the context of the particular litigation. They have a higher degree of respect for them, and I think they probably should have. And so the advantage of rulemaking is that it is not tied to a particular case. It's not the same thing as a brief in a current case. It's actually a more general rule. Most of it comes through the notice and comment process and has a fair amount of debate that goes into it. But I think it does have some potential.
So we only have 2 minutes left, so I'm going to ask a question to both of you. We have a world right now in which the EU has adopted one approach in the DMA. The US is still considering. What will happen? How are these models going to interact? Because there's a world in which they're quite harmonized, and there's a world in which they're quite not harmonized. And we have businesses that operate in both. What's going to happen, and how do we make sense of this?
Well, I think there are two possibilities. First possibility, there will be a Brussels effect, so the stricter rules will be adopted by these firms and used worldwide, or firms will decide to run different business models in different jurisdictions, and I think they will look at each single prohibition and decide which way is cheaper for them. Is it better to separate, to have different systems, or maybe to withdraw from a specific market, or is it preferable to apply the European rules? I think the European legislator comes with the idea of a Brussels effect. They like that. I'm not so convinced that this will indeed happen, but I'm also not able to predict what the companies are going to do.
Well, anything to add to that? I agree entirely with that. Everything really depends on extra-jurisdictional effects of rulemaking. Can you comply with the EU rule while leaving your US practice the way it is? That's a fact question, and the answer is sometimes you can and sometimes you can't. If you can, I mean, if a firm can comply with both sets of rules, then I don't think it'll have a major impact, but if there are significant extra-jurisdictional effects, then I think the Brussels effect will apply.
Press them, there you are. It's back to you. So I can't resist but giving Giovanna the last question. We have to keep it short because we're at time.
Okay. So, no, okay, if I have only a question.
And you have to press the button on your mic for the people to hear it.
So, Professor Schweitzer, I will be interested in knowing if you think that the DMA is basically a step back to the ordoliberal approach and the And, you know, and the concept of competition as a social institution rather than economic efficiency, because from my perspective as an European scholar based in the US, what I see is that yeah, the DMA seems to me a step back to the ordoliberal approach and the concept of competition as social institutions rather than, you know, the concept of competition as economic efficiency as it is applied in the US. Because, yeah, in okay.
Okay, now, my first remark, I think the DMA has nothing at all to do with ordoliberalism. Okay. Ordoliberalism, and ordoliberalism is not about a part, I mean, I think nobody would disagree that competition is also a social concept, but ordoliberalism has been concerned with efficiency. So I think the DMA is not a step back to anything. If at all, it's a step into a new world of public utility regulation, which will raise challenges that likely the Commission is not going to be able to meet. And I think we should discuss it more in depth because it has to do with, I'm in a way shocked that this is what you think about ordoliberalism, and you may know that I'm associated with the school, at least academically, and this is nothing to do with ordoliberalism, which has always favored freedom of competition. Yeah. And this is not freedom of competition.
Yeah, but freedom of competition as social markets, in a sense. Freedom because there is a certain number of companies in a market, which is not really freedom, in a sense. It's more an institutional, like a market.
Well, I think what ordoliberalism has maintained is that competition has something to do with rivalry. So either active, actual, or potential rivalry. If you, of course, you can say contestability has something to do with this concept of rivalry, but I wouldn't take issue with the concept of contestability as such in the DMA, but rather with the way it is implemented. But let's discuss it further.
We have the benefit of having you here for longer, so we will carry this conversation on further. I have one last responsibility, which is to give the third CLE word. The third CLE word is law, appropriately enough for this venue. And my last obligation as the host here is to ask you to please join me in thanking Professor Schweitzer and Professor Fabincare for such a stimulating conversation. And we will look forward to seeing you at events next academic year. Thank you.
Thank you.